Hey everybody, Yasha Sava from Sky Unlimited Legal Advisory, skyunlimited.law. Welcome to another episode of Ask Me Anything. I'm working from home today, love technology and the gig economy, so you see me in my comfort zone. Here we go. If a property is deeded but there's a mortgage, who's responsible for the deed? Whoever inherits that property, obviously. Is it the holder or the estate heirs? Parents had no will but deeded the property to stepson. So whoever owns the deed technically owns the home, but the mortgage is not necessarily an entitlement of that person that owns the deed has to pay that mortgage. So if your parents give property to you and they have a mortgage, they have a loan that they own to the bank, their names are on the loan, but all the mortgage says is this property has a loan tied to it and the house is collateral to that loan. So if that loan doesn't get paid, the bank can foreclose on the home and sell the home basically to pay that loan back. So be careful when you're gifting property to people that have a mortgage. Same thing with your estate. If anyone inherits a property and there's a mortgage to it, that mortgage is recorded and it's tied to the home. So if that loan still needs to be paid, either the estate is going to pay that loan out itself or whoever inherits the property inherits the loan. Okay. Also, if you're gifting property to a family member before you die, regardless of the estate or anything, keep in mind there is most certainly a due on sale clause that's going to be a part of the loan agreement. What that means is any transfer, not just sale, any transfer of any portion of the real estate interest, if not the entire home, just like a small portion of it. I gifted 50% of my home to my son so that his name is on the home deed. Then the bank might say, oh, sorry, this doesn't count. You're going to have to pay up the full loan because we're not comfortable with your son being a joint owner of the property because he can do whatever he wants with the interest. And now we get into a legal battle. So something to keep in mind there. If a house is included in the trust, can a trustee sell it because of fear of future possible lawsuits? So yeah, sure, why not? It highly depends on the terms of the trust. So a trustee has a fiduciary responsibility to follow the terms of your trust. So if you put your house in a trust and then you pass away and now your trustee, your successor trustees take over and they're taking care of the assets on behalf of your beneficiaries, well, the question becomes, is there any restriction on the trustees selling the property? For instance, do you want that property to be maintained for your beneficiaries or do you want them to inherit that house eventually? If your beneficiaries are minor children and the trustee sees, okay, they're going to need funds for college, they're going to need funds for cars, health, whatever they need, but there's not enough liquid assets, the trustee might sell the home because you might need that money. Same thing goes towards if you have any creditors on your estate. If you have, this actually goes towards the next question. If you have a lot of debt that you haven't paid off and then you pass away, now all those creditors are coming to the probate court saying, hey, he owes us a debt. What money does the estate have? If your assets are in a trust, technically those assets don't go through probate. So there is some protection there, but that does not completely allow you to avoid creditors upon your death. They still have some claims and they might come to your trustees asking for payment of any debt that's owed to them. Otherwise, they'll sue the trustees. So then your trustees have to find the money somehow. And if there's no liquid assets, then assets are going to have to start being sold. And that's mostly the reason why we see upon people's passing why there are a lot of estate sales that are happening to kind of liquidate everything. Another reason that happens is whenever you have multiple beneficiaries and there's just not enough assets to equally distribute. So maybe there's a house that's worth $1 million and then a bank account at $200,000. And one of the beneficiaries doesn't want the home. So you have to split everything 50-50, let's say, amongst all three siblings. How do you balance 200,000 plus whatever is left of that million? There's tricks you can do in the law, such as you can get a loan and pay that out. And then when the house goes to whoever it's supposed to go to, it becomes a part of a mortgage on the home so that the beneficiaries are happy. But sometimes that's not an option. There's no creditworthiness of the beneficiaries that are inheriting the home. So sometimes, yeah, they have to sell the home. That can be very sad. Next, final question. My 95-year-old mother, good for her, told me recently that she would like to liquidate her savings, about $500,000, and give it equally to us 3 children while she's alive. She's of sound mind, no issues. She lives alone at her house. 95 years old, living alone, sound mind. That's phenomenal. First, pat your mother on the back. Don't break her. Her will also provides the same when she passes, but she wants to give it to us while she's alive. She has outstanding health insurance and income and other resources. 95 years old and she still has income. Who is this lady? I need to meet her. And other resources as well. Is that okay? Okay. Your mom's 95 years old. She wants to gift you $500,000 and the will says the same thing. Your mom can gift whatever she wants to during her life, and as long as there's no undue influence of any kind, who cares? If she wants to gift it, she can gift it. Now, if her will says the same thing, then the moment she passes away, now, even though she gifted during her lifetime $500,000, unless she documents that somehow, this is $500,000, this is a gift that is counted against your inheritance. If she doesn't document that anywhere, then arguably you could say, oh, this was a part of the inheritance, so we shouldn't pay this out. But your other siblings could argue, no, that was a separate gift. And this will says that we get another $500,000, right? And keep in mind what we were just talking about. If there's no liquid $500,000 anywhere, then that's got to come out from some of the other assets, right? So if mom owns a home, there's a chance that the other siblings will argue in probate court while the will is being read that, hey, judge, tell our executor, who's probably you or another lawyer or somebody, to sell the home because we want to get that $500,000 written in the will. So there's no problem with her gifting during her lifetime, but if the will says the same thing, she needs to be aware she either needs to change the will and get rid of that $500,000 since she's gifting it now, or she needs to write on some kind of letter when she hands the money over to the kids that this is a gift that is part of their original inheritance. So that way, when the will is read and it says $500,000, it'll count against what she's already gifted during her lifetime. Right, if there's anything there left. No, that's it. All right, so as always, send me your questions. Somebody in the chat just said, when am I going to New York? I don't know if we're going back to New York for quite some time. We've got a lot of trips and travel planned. Ireland, Mexico, and that kind of stuff this year. I'm talking about me and Jasmine. So probably next year. Hope to see you. Thanks, Rhonda. I'm going to wave to you. There you go. All right, you guys, have a wonderful week and wonderful weekend. I'll talk to you next week in San Diego.